The United States technology sector relies on a massive, continuous influx of highly specialized foreign labor. Global engineering and computational talent funnels directly into American server hubs and corporate campuses to maintain the industry's pace of output. Currently, that reliance translates to roughly 1.3 million Indian nationals and their dependent families operating inside the U.S. under the temporary H-1B visa ecosystem. This animated diagram maps the structural bottleneck created by the 1990 Immigration Act. The H-1B program brings in approximately 85,000 new workers annually, with Indian nationals securing nearly 70%, but the law enforces a strict 7% per country cap on permanent residency slots. Moving down the funnel, we see the output valve. Each year, more than 70,000 Indian professionals file new applications for permanent residency, but they are competing for a legally mandated supply of just 9,800 slots. Because annual demand is 7 times higher than available supply, applicants join a backlog exceeding 1.1 million people. At the current pace of clearing just 9,800 cases per year, a new applicant from India faces a calculated wait of 134 years. The current arithmetic of the quota system ensures that high-volume source nations remain in a permanent state of backlog, with no mechanism in the 1990 Act to adjust for the scale of the modern tech workforce. For an entire demographic of skilled workers, a visa designated as temporary transforms into a decades-long holding pattern, leaving their legal status and professional mobility structurally vulnerable. For decades, every major attempt in Congress to modernize these 1990-era quotas has ended in legislative gridlock. With the path to reform stalled, the executive branch recently moved to occupy that policy vacuum. The strategy relies on bypassing Congress entirely. By introducing calculated administrative friction, the executive aim is to fracture the pipeline and force an active exodus of this specific workforce. The administration utilized 3 specific levers to execute this: venue restitution, extreme fee scaling, and nationality-based bans. These maneuvers immediately triggered massive corporate blowback from the tech industry and a wave of injunctions from the federal judiciary. We are going to deconstruct the mechanics of these 3 executive levers, calculate their economic fallout on the tech sector, and analyze the specific judicial logic currently keeping them in limbo. The first executive mechanism targets a 50-year-old legal precedent known as adjustment of status. Historically, this process allowed H-1B visa holders already residing legally in the U.S. to apply for their green cards domestically. They could transition to permanent residency without ever needing to leave the country. A recently circulated internal memo attempts to sever that domestic route. Termed the Go Home policy by immigration experts, it mandates consular processing, requiring applicants to leave the U.S. and apply in person at an American consulate abroad. For mixed-status families who have lived inside the U.S. for 10 to 15 years while trapped in the green card backlog, this creates an immediate logistical crisis. It forces individuals with deep community ties, property, and U.S.-born children to uproot and return to their country of origin simply to process paperwork. The secondary legal risk is even more severe. Exiting the United States to navigate an overwhelmed consular system can easily result in processing delays that break a worker's active H-1B status, potentially triggering long-term reentry bans. Recognizing the threat to their senior engineering teams, major technology executives mobilized immediately, delivering direct warnings to White House officials regarding the impact on corporate continuity. Faced with rapid, coordinated pushback from the industry's heaviest financial players, the administration was forced to quietly place the memo on administrative hold. The second lever utilized direct financial friction. This chart visualizes an executive directive aiming to scale corporate visa application costs. Historically hovering between $2,000 and $5,000, the new directive ordered the fee to spike to $100,000 per application. Issued with just 36 hours of notice, the order paralyzed human resources departments. Faced with an immediate, massive surge in corporate liability, massive tech companies, including Walmart, simply paused their H-1B sponsorship programs entirely. Imposing a 20 to 50-fold fee increase overnight triggered immediate multi-state litigation across 3 different federal jurisdictions. The defining counterstrike arrived from a federal courtroom in Boston. The presiding judge analyzed the mechanism and ruled that the extreme fee scaling did not qualify as a standard regulatory penalty or processing cost. Functionally, it operated as a tax. This distinction crosses a rigid constitutional threshold. The executive branch has no authority to levy taxes. That power is explicitly reserved for Congress. While this logic struck down the fee directive within that specific district, the administration is actively pursuing appeals in other circuits, including Washington, D.C., keeping the legal outcome fractured. The executive attempt to choke the visa pipeline through sheer cost was ultimately intercepted by the basic separation of powers. The third executive lever utilized sweeping national security proclamations to halt green cards, work permits, and asylum applications for citizens of 39 specific nations. The executive branch justified the block by citing domestic security concerns following a localized shooting incident, applying a blanket freeze to entire foreign populations. A U.S. District Chief Judge in Rhode Island intercepted the policy. The judge reasoned that denying an individual who has already paid fees and passed security interviews solely based on their country of birth is a clear violation of due process and equal protection rights under the law. But the administration downed an indirect multiplier for its goals that required no executive action at all: macroeconomic contraction in the tech sector. Recent market shifts led to over 100,000 tech job cuts globally. For an H-1B holder, a layoff activates a rigid legal countdown known as the 60-day clock. Within exactly 60 days, the worker must secure a new employer willing to sponsor them, qualify for an extraordinarily rare alternative visa, or leave the United States entirely. Even when federal courts successfully dismantle executive bans, the combination of a harsh statutory timeline and widespread corporate layoffs forms a highly effective de facto deportation mechanism. Federal courts hold the power to block executive overreach. They cannot, however, block legislation passed by the United States Congress. The legislative branch is actively generating its own market friction. Specifically, the Department of Labor proposed legislation that would mandate a 30% wage hike for foreign tech workers across the board. The core argument for the hike is that the minimum wage thresholds for American tech workers have remained static for 20 years, allowing foreign labor to outcompete domestic talent on price. Looking at this projected balance sheet, the financial weight of that legislation becomes clear. If enacted, this mandate would shift an estimated $18 billion in additional annual operating costs onto major U.S. employers. To manage those margins, companies would naturally restrict their H-1B hiring, reserving sponsorship exclusively for the highest-tier executive and specialized engineering roles, effectively starving out entry-level and mid-tier foreign talent. The relentless threat of sudden regulatory volatility, whether originating from the White House or Capitol Hill, creates an environment far too unstable for corporations to execute long-term talent strategies. The combination of a mathematically impossible 134-year backlog and continuous regulatory hostility is actively restructuring the global tech map. Canada emerged as the immediate beneficiary, capturing massive volume through its express entry system, which operates on merit-based points and clears permanent residency in a matter of months. The United Kingdom optimized its global talent visa specifically to absorb elite tech professionals seeking to bypass the friction of the American system. Crucially, these alternative destinations process talent purely based on economic value, entirely avoiding the restrictive, per-country quotas that paralyze the U.S. pipeline. But the most significant shift is happening internally. Domestic Indian tech centers like Bangalore, Hyderabad, and Pune are rapidly scaling their infrastructure. The elite engineering talent that would have previously spent decades waiting in the American bottleneck is increasingly choosing to build and remain in their home country. In response, multinational tech corporations are prioritizing operational stability. Instead of fighting hostile immigration law, they are simply relocating the work to where the talent is legally allowed to operate. While the specific legal architecture of American immigration restriction remains bogged down in federal courts, the global market has already calculated the costs. The pipeline of skilled tech talent has recognized the bottleneck, and it has permanently rerouted.